Hello, it's Yoli Medina, civil attorney here. Today I'm going to talk about the recent orders that the judge has put out. One was on the defendant's motion for leave to extend the discovery motion deadline, and the other one is the death penalty order strike or denying the death penalty be taken off the table. I know it's old news, but this is the first chance I've had to really make a video. So I wanted to talk about those. So let me put those up. First, let's start with the motion for leave denying the discovery motion cutoff date. Put this up. Okay. So this is the order denying the motion for leave. So I'm just going to read the first paragraph. It says, before the court is defendant's naked motion for leave, November 13, 2024, in which he seeks relief from the discovery motion's deadline of November 14, 2024, as set forth in the governing scheduling order. Defendant asserts his counsel and investigators are still reviewing the vast amount of discovery in this case, and therefore he needs additional time to file motions related to discovery. Okay, the second paragraph reads, motions to enlarge a deadline filed on the eve of the deadline are not well taken. And I agree with that. This motion for leave, she had from when? From the time that the scheduling order was put out, which was, I believe, October 9th, down here in the footnote. When it refers to the order, there's a 1 there, and the footnote goes down to the order, and that was on October 9th, 2024. So Ann Taylor had from October 9th, 2024 until November 13th. In between that time, she could have brought it sooner if she knew that she was going to need an extension on motions for discovery. Okay, so then it says, the state's discovery deadline was September 6, 2024. The defendant could have ascertained far sooner whether the discovery motion's deadline would pose a difficulty and brought it to the court's attention. And that's true. Further, and more importantly, defendant has not demonstrated with his filing good cause to enlarge the deadline. And good cause means, I'm just going to tell you, it just means the reasoning why you need to enlarge the deadline. You have to set forth with particularity why you want it continued or enlarged. And so I'll read the rest of it. He has not set forth what efforts have been made to review the discovery, what portion of the discovery has not yet been reviewed, why it hasn't been reviewed, or how long it will take to complete such review. Consequently, his motion is denied. So when he says naked motion for leave, I believe that what he's referring to, it's naked because it doesn't have any explanation. It doesn't have good cause. I know that in civil cases, we do have to provide a declaration stating our efforts of what we tried to do, what we've looked through so far, what is at issue, and why you can't review it in the time allowed by the court to bring your motions. And that was not detailed. And so I do think this is a proper order. I mean, you have to tell the judge why you haven't reviewed it and how long is it going to take you to review it. So I don't know if you all remember, but at the status conference, the judge did ask about the discovery, and this was the first time the Kohberger case was in front of the judge. And, it was like defense counsel or the prosecution, Ashley Jennings just looked at Bill Thompson when he looked at her like she's going to address that. And Ashley Jennings looked at him like, what? And basically she just said she would defer to the defense. And the defense says, well, I haven't reviewed most of it, or, I haven't looked at it. And it just seemed like a big ball of wax. I mean, it's just, nobody knows. So, by denying this motion to extend the discovery motion cutoff date, he's setting parameters like you need to get this done. And if you notice the footnote number 2, he gives them some leeway and says this order does not foreclose discovery motions pertaining to the new or supplemental discovery responses, or in the event new information comes to light requiring additional discovery motions. So that leaves it open for anything new or anything that's supplemental that's going to be provided from the time he signed the order going forward. So it doesn't totally foreclose it. It just, he's sticking to his order, and he's telling them, you have to tell me why, what have you done? Why haven't you done it? What needs to be reviewed? How long is it going to take? It's who's reviewing it? How many people do you have reviewing it? And it's the who, what, when, why, type of thing that he's looking for. And that's likely why he said it was a naked motion for leave. So that's my opinion on this order denying the motion for leave to enlarge the discovery motion deadline. And if we go to the decision that he did denying the death penalty motions, I will say this page is, this memorandum and order is 55 pages long. He really dissected it, each motion. And so I think, I've never seen a memorandum and an order that's 55 pages long, but I do civil cases. So, but I've had some big civil cases where it's not, we've had a lot of paperwork, but never have I seen a 55-page memorandum and order. So it might be common in death penalty litigation. I just don't know. I don't know, because I don't do that. But the fact that it's 55 pages and it talks about all of the law and the standards and everything, and I'm not going to go into detail, but this is, and this order came out reasonably quick. It came out pretty quick considering the motions were just not too long ago. So I think this judge is on the ball, and I think he's going to make the right decisions, I think. And although some of you might think that this judge is slamming Kohberger and he's railroaded, that's not the case. This judge is trying to keep control so that the case doesn't go off the rails and where you don't know what's happening. And for instance, I still don't know what happened to the alibi defense. They were supposed to talk about it, and I don't know, but I'll do a video on that one. But in any event, these are my thoughts. So let me know what you think, and I hope this alleviates any fears that you think that this judge is just, trying to railroad Brian Kohberger. I don't think it's this judge. If anybody's trying to railroad Brian Kohberger, it's not this judge. He's going by, he is keeping control of his courtroom. So, and I think he's going to make the right decisions. It's just that we don't know what evidence they have because it's all sealed, so we can't see it. So we don't even know what, for all we know, they could have a note to his dad confessing he did it. But I don't know that that's true. They just wrote in one of the search warrants, one of the returns had a note to his dad. I don't know why that would even be relevant unless it had something to do with the case. But anyway, we never know, and we might be really surprised when the trial comes and we're like, oh, I see. But initially, I agree that, some of the facts, especially the probable cause affidavit, doesn't make sense. But in any event, those are my thoughts. Let me know what you think.